Litigation. My name is Diana Cohen, General Counsel at Dr. Bronner's and the ACC Immediate Past President. It's my pleasure to introduce our three esteemed panelists for today, beginning with Ryan Nell, shareholder at Pettit Kohn. Ryan focuses on employment matters and is the attorney that I personally call for questions ranging from the mundane to those oh snap moments. He's joined by his colleague, Heather Rogers, an associate attorney in the firm's retail team, representing clients in a broad range of cases from premises liability, products liability, and personal injury, the three Ps. And to balance out the panel, we've got a corporate perspective. We welcome Melissa Solomon, General Counsel at Oakmont Senior Living, which I can only imagine deals with a myriad of issues from employees to residents, regulatory, and healthcare, to name a few. So with that, I will pass it along to the panelists. Thank you.
Thank you very much, Diana. Thank you, everyone, for being here. As Diana mentioned, my name is Ryan Nell. I'll let each of my colleagues here introduce themselves as well. But what we're going to offer you here today is kind of a few different perspectives on what we are seeing in California, which is, to put it bluntly, so many cases, right? And the idea is going to be, how do you identify the ones you want to fight? How do you identify the ones that you want to settle, and everything in between? Because as those of us who deal with this every day know, and I think a lot of you know firsthand, not all cases are created equal. There are a lot of variables that go into these things, and we can't talk about all of them, but we want to talk about the ones that jump out to us. So we're going to do this broadly, right? We'll keep the reins on and we're going to jump in. We don't have a firm outline of who's going to talk about what and when. We're just going to be conversational. If you have any questions, I've got the chat function open on my screen. So feel free to drop anything in there that you'd like, and I'll find a way to kind of get it in there. If you have separate questions you want to ask them proverbially, in the hall after this, feel free to reach out to us as well. But before we get started, let me allow Heather and Melissa to introduce themselves.
Sure. Hi, everyone. My name is Heather Rogers. As Diana said, I work on the retail team at Pettit Kohn. We focus primarily on general liability matters, premises liability, personal injury, products liability, that type of thing. So a lot of what I'll be talking about today is what I see in terms of value drivers and best strategies for determining which cases are the best to go to trial, which cases are the best to settle today. So that's the perspective I come from.
And good afternoon. My name is Melissa Solomon. I am General Counsel at Oakmont Management Group and Hartford Hospice. As Diana indicated, we are the largest senior living company in the state of California. We've got just over 9,000 employees. We've experienced really significant growth in the last 5-6 years. Certainly the frequency of litigation we've seen it escalate over the last several years. The plaintiff's bar just continues to be more and more sophisticated and more collaborative. And it's really important for us on the defense side to try to spend more time in things like this, where we're really working through strategies and to get some successful results. So good to be here, and thank you for having me.
So we're going to jump in a moment to talk about trends, just kind of the raw data of it. So Heather's going to walk us through that. But we just want to kind of calibrate the goals here, right? Because what we do as outside counsel, so what Heather and I specifically do, is we're working with clients all day, every day. And that runs the gamut, right? So that means that we're dealing with sophisticated general counsel like Melissa and Diana. We're also dealing with some less sophisticated general counsel. We're also dealing with non-general counsel. In my practice, right, it's employment, right? So that means it could be a mom and pop that has 2 employees, or it could be a Fortune 1 company, right? And the cases still need to be analyzed the same way. And often what that means is it always means we need to be objective. And it means that often we have to give news that is not what people want to hear. But what we need to do is understand and express that information in a way where we can explain what the variables are, how we handicap them, so that way our clients, whether big or small, whether with sophisticated counsel on the other side or not, can make the appropriate decisions and guard your time, guard your money, and go from there. So Heather, do you want to talk just a little bit about the trends that we're seeing? And since I have the range, you can tell me when to stop and when to flip, but tell us a little bit about that. And then obviously, Melissa, jump in any point too, if you want, and we'll go from there.
Sure. So this graph is part of a report that's put out every year by the Judicial Council of California. There's a link at the bottom, and I'd encourage you all to take a look at that report. There's some really good information in there, and it really drills it down into what types of cases and the caseloads of judges typically throughout the state of California. So take a look at that. There's really good information there. Specifically, this graph shows total civil filings and dispositions in California for the past 9 years. So if we look at fiscal year 2024, last year we saw the highest number of civil filings ever in this state. You can see in this graph that it goes back to 2015. Back in 2019, California had an increase in civil filings. But once you go to the data, if you click on once you go to the link and go to the report, if you click on the top right corner, get this data, it will break it down, and you can see that in 2019, it was still about 3,000 less civil filings than last year in 2024. After 2019, you can see we have a drop in civil filings during the pandemic years, but that's been increasing rapidly since 2022. At the same time, dispositions of civil cases have been down since 2021, which again is likely a result of the COVID pandemic, causing court backlogs and delays in a lot of things. But as you can see, they're lower than they've been in the last 9 years currently, dispositions. So in total, last year, California saw 886,644 total civil cases filed. Of those, there were 278,901 unlimited cases filed and 530,282 limited cases and about 77,000 small claims cases. Ryan, you can go to the next slide.
Sure, and let me add one thing on the strategy, right? If you see that the big delta that we have here in the dispositions versus filings, that's an opportunity, right? Because what it means is if a plaintiff is filing a case, they're getting in line behind a lot of other cases. And we're seeing, and Heather and Melissa, tell me if you've seen otherwise or experienced otherwise in cases that you're handling, but increasingly frequently, we're seeing trial dates that are at the onset, years and years away. So if you're particularly in Los Angeles County, San Diego County, seeing this as well, you're seeing trial dates that might be at least 2 years out when they're getting set. And that's assuming that it moves as quickly as possible. What that means is there's some opportunity there. If there's a case that you want to settle, and you can tell counsel, look, you want to try this case? You're waiting a long time to have your opportunity. So something to consider as you do.
Absolutely. And I would even say that, we're oftentimes moving to compel arbitration, and we're even seeing, the dates for those hearings set 6-9 months in the future. So we're just sitting around twiddling our thumbs for 9 months before we even know what venue we're going to be in.
And even on those cases, and we deal with some of those for you, right? Where we're seeing arbitration dates. Once they get compelled to arbitration, it used to be arbitration. You could set your watch that, within a year, I'm going to say your watch, but close. So within a year, you'd have disposition of that. I'm seeing arbitration dates 18 months out now, where they're getting scheduled, which is never happened. It used to be arbitration was faster. It is faster, but it's then court, but it is still a lot slower than it had been, which again creates leverage, right? So there's an opportunity there to say, look, you're going to have to wait. Otherwise, you want a couple bucks now, we can talk about that.
Right. We're certainly not back to pre-pandemic kind of timelines on these things, and I don't know if we will anytime in the foreseeable future. If anything, it's a little bit slower than I think it was like a year ago, at least here in San Diego. So this next graph just drills down a little bit further on the civil unlimited filings for 2023-2024. And as you can see, 82% were either settled or dismissed before they got to a trial. Of the total civil unlimited cases at issue that were not settled prior to trial, That's 18%, so only 2% were heard by a jury. And then trial de novo, 5%, by the court, 93%. I was actually a little bit surprised by this. I thought it was higher than 82% were settled prior to trial or dismissed prior to trial. But if you go back, the Judicial Council of California also has past reports, so you can kind of compare and contrast. I think settlements have stayed kind of around the same sort of range for the past several years. Anything to add?
Not particularly, other than look, it's no secret that, you know, looking just at the jury, what goes to jury, 98% of cases never see a jury. And so I'll say this myself, I have far more than 98 or far more than 2% of my cases start with a client saying, we're taking this to the end and we're going to fight tooth and nail. The jury's going to have to tell us we owe something. And statistically speaking, that's not how it goes. Some cases go to trial, and if you want to take it, we're happy to do it for you, but you have to be selective. And so I think part of the role of a good outside counsel is to be a sounding board, allow someone to say, we understand that and we're going to fight for you, because we will. And if you want to be one of those 2%, that's fine. But we also need to be pragmatic. And the charts show us that it is a 49 out of 50 shot that you're going to settle your case. So let's try to figure out what that is and at least let you make an informed decision.
Let's talk a little bit about nuclear verdicts. First, what is a nuclear verdict? Some folks define it as a jury award that exceeds $10 million. But I think a much better definition is any jury award that substantially surpasses awards and typical precedents for similar cases. Based on my research, currently California has had the most reported nuclear verdicts in the United States. What I have here is between 2013 and 2022, there was a total of 199 verdicts amounting to $9 billion in jury awards. Per capita, Florida has more nuclear verdicts, but California is lockstep right there with some very significant verdicts in the past 10 years.
Yeah, and they're coming to our shores here in San Diego as well. So, you know, this technically is a San Diego group. We used to say we were less concerned about it. LA, we called the bank because that's where plaintiffs go to get paid. That is now, it's spreading south. And and Heather has some awesome stuff that we'll talk about later about particular jurisdictions and a nice chart and all this. Really, it's really well done. So I'm not gonna steal that thunder, other than to say, in San Diego, there was just an employment case in San Diego. They got something like a $14 million verdict that you never used to see those numbers. And now all of a sudden we do, and we have to be aware of them. Now, that doesn't mean every case is a $14 million case. Of course not. But that's driving settlement demands because they're saying, well, somebody got it, therefore I got it. So.
And I'd say that trend is also spreading to San Bernardino and Riverside counties as well.
Yeah. So.
And I operate a lot in Northern California, and we've been there a while in Sacramento County. So, and especially depending on what industry you're in, I'm in senior housing, long-term care. You know, we definitely over the last several years have seen on average in California alone, you know, 1 to 2 nuclear verdicts in Northern California. So and there's a lot of people that have a lot of reasons why we think we're seeing it. We're talking about billionaires now instead of millionaires, right? So what's a couple $1 million bucks? Not that much, right? Well, it is a lot of money when you're actually talking about real money. But the average people are thinking about billions of dollars instead of millions of dollars today. So it's just a different landscape, unfortunately.
Yeah, one of the things that we'll do in higher profile cases or higher dollar figure cases, we'll do what's called a mock jury, right? Where we'll go in and it's a focus group, and when they come in for the day, they don't know if they're testing new flavors of Sprite or they're going to do something like a mock jury, and so they come in and do that. And I had one recently that happened. It was on a personal injury case, so it wasn't my case. I actually technically came in to be the defendant, so the attorney whose case it was could pretend to be the plaintiff, because that's kind of an easier transition for him to just take the other side. And so we give our closing arguments. The jury doesn't know that he and I are partners. They hear it, they listen to it, and then what they do is they take the 24 people and they put them in 2 rooms. And the same exact jurors, right? So they heard the same exact words from all of us. They were paying attention. They were doing our job. One room came out at something like $500,000 and the other room came out at $18 million. So I say that for two reasons. One, they heard the same thing and somehow they got somewhere different. Two, the way that you watch people through the one-way glass, the way people talk about money is different now, right? The way they throw it around. And once that ball started rolling, it's fake money, so it was okay. But oh my God, right? Well, you know, we gave her 3 million on that. Might as well give her 5 million on this element of damages, whatever, and this and this. And it stacks. And people just have a different relationship with money, especially money that's not theirs, especially if there's a perception that it's deep pockets on the side, right? So not ideal for this room because we're all on the side of the defense here, but it's a reality. Let's talk a little bit. Oh, I gotta do. So Heather's going to talk to us a little bit about value drivers and the general liability matters, and then Melissa and I can hop in on the cases that we see as well. But let's Heather take the floor for a while and just tell me what to do to steer.
Sure. And I think this transitions well from what you were just talking about what are the value drivers to a jury in terms of what injuries they're going to be hearing about at trial. They're going to be driven by emotions, and what are the ones that are going to be really impactful for a jury to hear about? Obviously, loss of consciousness. Plaintiff will give, very good, potentially good testimony that's going to draw emotion in terms of loss of consciousness. Surgeries versus surgical recommendations. Once a plaintiff has a surgery and you're at trial, it's often difficult to show that that surgery or the decision to have that surgery was unreasonable, especially if the plaintiff is taking the advice of their doctor. It's unlikely, except in exceptional circumstances, that a jury is going to punish them for that or find it unreasonable. At least in my practice, what I'm seeing a whole lot more is CRPS. That's, I think it's chronic regional pain syndrome is being claimed in so many cases that I see. We're seeing a lot of different plaintiffs undergoing spinal cord stimulators, even if CRPS is not claimed. It's a way that will drive up special damages by several $100,000. And often a temporary spinal cord stimulator is put in, it doesn't work, it's taken out, the costs of that are exponential. So things to look for when you are seeing CRPS cases is obviously absence and insufficiency of psychological testing. The plaintiffs have to go through a whole series of psychological tests before CRPS diagnosis can be made. Also, if they've skipped conservative treatment, it's just going straight to spinal cord stimulators, straight to a CRPS claim. Those are things to look for. Those are injury value drivers from my space. If you two want to follow up on that.
Yeah, Melissa, I don't want to.
No, go ahead.
Okay. In employment cases are inherently sympathetic, right? And so it's rather uncommon that we have the types of damages that are being, well, certainly not the specific damages that Heather's talking about, right? Because we're not having personal injuries, otherwise it'd be a personal injury case. So occasionally we'll see treatment for emotional distress, because typically in an employment case, the two types of recoverable damages are lost wages, which is front and back pay, so what you would earn up to trial and thereafter, and then emotional distress. There can be punitive damages, and the big driver on employment cases is attorney's fees, which is its own separate animal, but we could talk more about that. But specifically what it means is if you lose $1 on an employment case, you're very likely going to have to pay all the attorney's fees the other side used to litigate it, and the jury's not allowed to know about that. So that's very often the tail that wags the dog. But focusing on the actual recoverable damages, punitive damages are pretty uncommon in employment cases. It happens, but not very often. What we're seeing more is emotional distress damages being utilized as a form of punitive damages, right? So it's not, in fact, there's a jury instruction that says, don't do this, but they do. And what they say is, okay, well, we need to find a way to punish the company for something that is perceived to be bad action. We don't think that it rises to malice, fraud, or oppression, which is what's required under the code for punitive damages. However, we want to teach them a lesson. So what we're going to do is we're going to inflate the emotional distress damages. On these big cases on the employment side of things, where we're seeing huge verdicts, in almost all circumstances, it's, well, there can be punitive damages awards, but in almost all of these circumstances, we're seeing really big, not really grounded in reality, emotional distress damages, which actually change how we have to report things now, because we need to say, look, normally we would say that this would be a $150,000 claim soaking wet at trial. Now they're going to ask for $3 million. And there's no real reason for that other than that now the playbook says so, but that's what it is. And everybody comes into a jury on an employment case having a boss they didn't like once, or having something that happened to them once that they didn't appreciate. And they come in with those biases, and when given the opportunity, more and more they're jumping from what is technically recoverable to having the power to do something special.
If we want to talk about types of damages, we have cases on the GL side driven by special damages. If the amount of past medical treatment is significant, what type of treatment did the plaintiff undergo? Was that through a lien treating provider, or statutory lien, meaning Medicare, Medi-Cal, VA, TRICARE, or a lien doctor? So if it's attorney-driven lien treatment, we're going to see highly inflated past medical special damages. How do we go about attacking those at the time of trial? Sometimes when I have cases that have large lien treatment amounts for past special damages, sometimes it's easier to negotiate with plaintiff's counsel because he knows or she knows, and I know that those amounts can be negotiated down. And what can we do now to put additional money in the plaintiff's pocket and settle the case rather quickly? Or is it one that plaintiff's counsel is intent on taking all the way, in which case my strategy sort of changes in terms of negotiating settlement. But I want to focus on is cases that, like Ryan was saying, cases that are driven by general damages. On the GL side, oftentimes I have cases with low specials, but high general damages. I have a couple examples here. I had a case a few years ago. It was a motor vehicle case, and it was a pregnant driver who claimed that her pregnancy was made risky or extremely uncomfortable as a result of the accident. She hardly received any past treatment, but she had factors that made her a highly sympathetic plaintiff. She was already the mother to a Down syndrome child and was dealing with this pain from this accident that was going to make her a highly sympathetic witness at trial. So explaining to my in-house counterpart what that meant in terms of case value and how are we going to value this case for settlement. You can move on. I have another example here. This is the case I currently have. It's a sexual assault case in a strip mall parking lot. Again, I have past specials that are relatively low, $38,000 in this case, which I anticipate that the plaintiff's counsel is going to waive at the time of trial. Because of the nature of the incident, it's a very compelling story. This plaintiff is a very compelling witness. And through no fault of her own, she was sexually assaulted in this parking lot and has suffered significant emotional distress damages. So in terms of speaking with my client and valuing this case and looking at exposure, what does that look like from our perspective? There are other factors here in terms of joint and several liability, which I'll talk about a little bit later. But basically, in terms of evaluating it, what are the hard factors that I have? I've got a plaintiff who's had cerebral palsy since birth. What she was shopping at this strip mall, buying water for a church picnic. I mean, it's a compelling story, and there's a lot of value drivers there. General damages value drivers. Go ahead.
Yeah, and I'll just a lot of these things are hard to articulate because they're feeling, right? You know, it's one thing to say, if it's a general liability case, say, here are the past meds, right? There's a number on that. Or you talk, recoverable past meds or whatever it is. Or in my case is lost wages. I can put a dollar figure on that because I can say this person was earning this much money. Here's what they would have earned if they kept working for us. Here's what they've done to mitigate. It's a math problem. But the things that seem far more so to drive value are the things where you can't put a number on it. And it makes sense, right? Because it's easier for a plaintiff's counsel to ask for a bigger number if they don't have to justify it based on something specific. And so what we're seeing is we have to look at these things empirically and say, look, this is what the cases are driving. This is the sometimes, for lack of a better word, gut instinct that you get on this, right? We think that the plaintiff is really likable. I've had cases where we go, in fact, there's an example. I had a case where general counsel, who was sharp on a case, sat in deposition with me, and I deposed this plaintiff on a case where there were some allegations, not of sexual assault, but of kind of just harassment that wasn't the worst sounding thing in the world, but wasn't great, right? And there were things that this plaintiff said that we know to be verifiably untrue, but she said them in such a way, and she was sympathetic in the exact right way. She cried just the right amount at just the right time, and everything was picture perfect, that we settled the case the next day. Because we said, you know what, there's too much risk on this, and it's hard. I'm glad counsel was there, because I was going to have to go back and have that conversation. It was counsel who came to me and said, oof, no, because it wasn't for lack of facts on our side. We could have explained it all the day long. But at the end of the day, you had someone that if she was going to sit there in front of a jury, there's a story to be told there. So we needed to avoid it.
And I'll say that as in-house counsel, I mean, there are times when I will sit in depositions. I don't typically sit in depositions, right? But when you have those types, if you're deposing plaintiff, and it's a story like the one that Heather just, kind of iterated, you want to hear how it makes you feel, how you would anticipate it would make a jury feel, because juries will disregard the law if there is a compelling story on the other side and they think there's a deep pocket that can help that person that has the story. So I do tend to say, I definitely want to be present for this deposition. I want to see what the demeanor of the plaintiff looks like, or a particular witness. Because that helps me then go and have the conversations with my C-suite, my leadership teams, to say, no, we need to think about this differently, because of where, the potential here. So, it's stuff, and or maybe this is one that you think about, submitting to a mock trial, to a mock jury, and getting that, you get the videotape, right, of the deliberation sometimes, and you can use that to help inform your decisions moving forward too. So all very helpful, and yep, that's what's driving these nuclear verdicts, I think.
Do you want to jump back in?
Sure. In addition to just the plaintiff's damages, also looking at what other damages are at play in the case. The first one I always look at, obviously, if there's loss of consortium claimed, or any third party damages. So I have a case currently right now, which is an assault case in a retail space of a mother who was basically assaulted by a homeless person in front of her two 12-year-old daughters. Those two daughters are named as plaintiffs. I think they do have a Dolin v. Lake claim, and going through that analysis, and when you're evaluating what the damages are in this case, taking all of those things into consideration. I have obviously punitive damages here. When you see the punitive damages, looking at, are they properly pled? How do you want to strategically approach them, through a motion to strike or a later MSJ? And then I think there are a couple others, but I don't know if you two want to talk to derivative claims on the employment side.
We don't, that doesn't make
really
much sense in our context, so I will, for once, not add anything or have anything to say. But Melissa, if you want to jump in, otherwise.
I mean, yeah, we'll certainly talk more about, punitive damages claims and how we handle those on the professional liability side. We see those almost in every PL case that we have. But yeah, we do try to manage those early on with the MSJ process, through the MSJ process.
And I will jump in. There's a question that came in that on stipulation on employment law damages and cases, which is a good one. So what we would refer to, so questions about stipulating to the idea of what we call garden variety emotional distress damages, meaning there's no treatment Typically, it's just what normal course and scope, anxiety, depression, that sort of thing. But we agree that no one's been treated. And the question, which hits the nail on the head, is it's hard to define exactly what that means, right? So here's how it often plays itself out. If there is a claim in an employment case for intentional infliction of emotional distress, so what we call an IIED claim, you almost always have the opportunity to perform what's called an IME, an independent medical examination of the plaintiff. And you're going to want to do that because you want to evaluate the extent to which this individual, A, has been harmed by the alleged bad action in your case and by your client, and B, the other things that have happened for this plaintiff, right? I took a deposition of a plaintiff last Wednesday or Thursday who I will spare everyone the details, but has lived a terrible, horrible, wouldn't wish it upon your worst enemy life. Has been through so many horrible things. And we're going to try to find a way to get this case resolved if it makes sense, because otherwise, this plaintiff's going to have to sit through an IME and talk about these terrible things. And we're going to have to spend a lot of time talking about the other reasons why it's a difficult life. And so if counsel doesn't want to go down that path and doesn't want to have an IME, what they will sometimes offer is say, well, we'll just agree that we're going to pursue garden variety emotional distress. The problem is that really defies definition. You kind of generally know what it means, but you don't know exactly what it means. And so I don't like those types of stipulations unless it comes with elimination of a claim. So in other words, you get rid of an IAED claim. Yeah, we're going to stipulate to garden variety emotional distress, but I still need to be able to evaluate it. And I still need to be able to determine if I have to have either an expert or something to testify on it. Because what I can't have is, oh, we agree it's garden variety, but my garden variety is worth $500,000 and your garden variety is worth $100,000. That's a big delta. So I hope that answered the question. That's how I feel about it, at least. But again, to the individual who asked that question, if you have more specific follow-up, either directly or indirectly, feel free. Heather, do you want to talk a little more about punitive damages?
Sure. I mean, at least from my perspective on the general liability side, like I said, are they properly pled? How do I want to advise the client of when to attack them? If it appears that it's properly pled, probably the better plan is to go through a later motion for summary judgment. But oftentimes, almost always, we just do a motion to strike, demurs, motions to strike early and often, and throughout that time period, reaching out to plaintiff's counsel, taking their temperature. What are you looking for in this case? How are you valuing this case? Getting as much information as I possibly can informally during that process, while we're doing initial motion work.
Unemployment cases, it's not always pled, and when it is, it's often weak. It's sometimes hard to get, even though it seems like it shouldn't be, it's hard to get punitive damages eliminated in unemployment cases because often the conduct is by a managing agent. So in other words, and that's part of the standard of who did. I'll stop before going too far into the detail of the nuance of the law on it, but the actors that are engaging in the action that is leading to the lawsuit or employment case are typically people who, if it is bad enough, can be bound by punitive damage. So it's not impossible, but it's kind of hard for us to get out. So that means that a lot of times we kind of have to roll with it, and we'll roll with it to trial or to arbitration. That's not a complete block against it. If there's a way, we're going to try to get it out, but you kind of just have to call it what it is.
So talking a little bit about joint and several liability, in most of my cases, or a good number of my cases, I have multiple defendants. And in my evaluation of case value, what does that mean for exposure? So in California, each defendant is separately, assuming that each defendant is found liable to some percentage by the jury, each defendant is separately responsible for their share of non-economic damages and is held jointly responsible for economic damages. So I have an example here that most of you may know, but that analysis essentially is, say that plaintiff receives an award for $5 million, made up of $2 million in special damages and $3 million in general damages. Your client, even if they're found 1% liable, and co-defendant is 99% liable, the exposure is $2,030,000. And I've seen a lot of cases where that analysis isn't fully played out. And I think that that's important when we're determining what do we want to do with this case, take it to trial or not, who is the co-defendant, what does the joint and several liability mean in reality in my case. If the co-defendant is, for example, in the assault case I was talking about recently, a homeless person who's in prison, then my client, then joint and several liability really means that my client is fully on the hook for all of the general damages. So the exposure goes from being very little to, when you put joint and several liability in play, significant.
There's a question that came in, which is a good one, about kind of working things up early and trying to see if there's a way to get something done early. I am also, the question was in, I don't know if everyone can see it, I think so. And it was in both the personal injury and the employment context. So I'll speak specifically to employment, and I'll let Heather and Melissa jump in and any nuance on their practice areas. But I believe firmly that you need to work things up, you need to work things up quickly, and you need to try to perform some sort of assessment, right? Because whether it's because it's a requirement, as it is for some clients, or it's just a best practice, what we as counsel need to be able to do is handicap and say, look, here's what the potential exposure might be, and here are the options, right? So my obligation, as I see it, is to make options available to my client. One of which is to take it to the end and finish with closing argument, right? And wait for a jury to come back. But it's also I want clients to know what is the settlement value in a case. What would it take to get this done? And it may well be that that's not appetizing and you don't want to make that deal. So be it. But if I feel strongly that it's worthwhile for the client to know what that is. Now, the question, or the kind of call to question asked about early reasonable settlements, and if that's still the case, less so than you'd hope. And I think the reason for that is a lot of what we talked about already, which is the fact that there are huge verdicts, the fact that everyone's litigating things aggressively. There is a group called CELA, which is consumer, it's in LA. And it kind of writes the playbook for plaintiff side employment attorneys and how they operate. And the playbook now says high demands, you do this, this, and this. And so what that means is we are less frequently seeing reasonable demands early in litigation. Instead, we're seeing people in the clouds. A kind of next step to that, it used to be that we would almost always say, well, if we're going to go mediate a case, which by the way is the manner in which most of these cases settle, is to demand that we want some sort of pre-litigation demand. Or pardon me, pre-mediation demand. Where are you going to start? And we start there. Now I insist upon that almost never. I'll take it if it comes in, but the reason why I say that is because we know that when we go to mediation, their opening demand is going to be absolutely astronomical. And so what I want is I want that to be communicated at a time where the mediator is there and can say, that's ridiculous. Not so much for plaintiff's counsel, but for the plaintiff, because the plaintiff's going to hear, you know, let's say this is a case that should settle for $100,000 and they start at $5 million because they think they have to do that. I want the plaintiff to immediately hear, thank you for giving me that $5 million demand. You're insane. I'll bring it to the other side, but understand that that's nowhere in the realm of possibility. Versus if plaintiff makes that demand 3 months before mediation and then is spending that $5 million in their head until they get there, it may be harder to disabuse them of the reasons why they can't actually get that. So there's that. And then there's the follow-up question that I'll address, and then I want to pass it along to Melissa and Heather. Often tried to settle prior to them getting counsel or just after they got counsel. Yeah, early on is great. It's going to depend a lot on if there's counsel, who it is, because good counsel should work up their case. On the topic of before they get counsel, I will fight to the ends of the earth that separation agreements are the best money that a company can ever spend forever and ever, no matter what. If you're letting someone go, you should always consider that, because someone has once they leave, if they haven't signed an agreement for whatever it may be, dollars wise, technically they can go and they can make your life painful in time and effort and in money. So my preference for anyone that has ever let go is have them sign something. And even if it's something small and they give it away, I would much rather that than before they start talking to the lawyer, they start having the conversation. I see another question came in, but I want to make sure Heather and Melissa have a second. So I'll read that and then we can get back to the questions.
I mean, from my perspective, I totally agree. You know, the sooner once you start, if you understand what the allegations are, going in, you know, expeditiously, working up the file, looking at the documentation, how well positioned are we just based on the documentation that we have, and certainly in the employment context, you know, that's going to be. I mean, it's always important, but I feel like every time I start to bring the teams in to ask questions about, you know, how to, the separation, it just starts to muddy the waters, and the documentation is usually, it's either there or it's not, right? So we'll make determinations early on when we get those initial demand letters. I will admit that sometimes it depends on who that demand letter is coming from. You know, we get how many a week from Abramsons and Lawyers for Employment Fairness, you know, so those are if we still work them up, and we still, I mean, for those guys, we know that if we've got something in the file that we don't like the look of, well, then there's certainly an opportunity to get something done for pretty low dollars to get rid of it. But you know, some of the better counsel, you know, they're going to work up the case, they're going to know, and you can, you know, certainly attempt to engage them in those types of discussions. And then, you know, I do this also on the professional liability side. We get opportunities to when we have a concerning outcome with some potential exposure. I mean, we have to be real honest about what happened, what transpired, what's the timeline. We're trying to dig into those things as quickly as possible. And certainly if we have an opportunity to reasonably come to an agreement with a family or with a resident, we're going to take it. We're going to get that settlement agreement in place and build that into that process. So it's certainly something that is, if you've got the ability to act quickly and thread the needle on that, very worthwhile, because you'll spend more in defense costs even just to get, you know, through the first 6 months of litigation.
Yeah, and on the GL side, I can tell rather quickly when I get a demand or when I see medical records what type of case this is, what type of plaintiff's firm I'm dealing with. If it's attorney-driven lien treatment, I'm evaluating it slightly differently than if obviously the plaintiff treated at the VA. I feel like that is a better indication that the treatment that they received was reasonable, was necessary, than if it's attorney-driven lien treatment. But oftentimes, again, if it is attorney-driven lien treatment, I'm still reaching out to plaintiff's counsel as soon as I get the case, because that is sometimes one that can be settled rather quickly if it's not one that the plaintiff wants to continue fighting and continue treating and continue working up. I think that goes to the next question, if you want to address that, Ryan.
Oh, as in the question that came in, yeah. On the chat, so there's a question in the chat that came in about you know, insurance companies saying, okay, we'll go settle this thing early for $100,000 because that's what nuisance, well, it didn't say this in the question, but that's what nuisance value is, and you can make a decision based upon cost of defense. It's always going to cost you more than that to litigate a case, therefore you should just make the deal early. And what that does, it's no secret, is it drives up premiums, and you know, you pay now, you pay later. I hear that, and we have that conversation a lot, right? Because on employment cases, companies should have employment practices liability insurance, which means on, not all, unfortunately, but most of my cases, there is an insurance adjuster somewhere in the process. Now, these policies are typically consent policies. I'm not a coverage counsel, but you know, usually there is some agency with the insured client. So with all of you, you know, the way I look at these is you need to find the right deal, and you need to be aware of cost of defense, because again, without being an insurance adjuster or underwriter, they're going to look at your loss runs, right? So it's true to say that, you know, if you're looking from a premium standpoint, if it costs less to get it done, there may be value in that. But I think money well spent can drive value down, right? The way I look at attorneys' work and things we want, I want everything that we do to be strategically crafted to try to drive the value of the case down. So in other words, if a case can settle for $20,000 today, it doesn't make sense to do $21,000 with the work, because why the heck would you do that? Even if you get a zero at the end. Now, there can be strategic reasons, and that's nuance, so we can go into that. But there are mediators that will tell you these days that a nuisance value case in California on the employment side of things is $60,000 to $80,000. I think that's too high, but it's not super wrong. So to rebut that, rely on your policy, right? You have to consent to these things, but also listen, right? There's a reason why the insurance companies are doing this. I think they're trying to drive value down, which does typically help. But utilize your counsel and have that counsel use their time effectively to do things that drive value down, that push the case forward, that aren't just billing to bill because there's no reason for that. Hopefully that helps. And there's a question here on retention, which I think I just saw come in, which also makes sense, right? If you can get it, if you have a high SIR, deductible, self-insured retention. Again, I'm not a coverage guy, but what I can say is, you often have more autonomy there and can work on that. We're seeing a lot of policies written in California that have really high SIRs. So there's a lot of autonomy for the insureds that they can do it. And then they have insurance in case things go sideways, whether by necessity or by choice. I think that's going to become more common for everyone in California.
Right. Do we want to talk about liability?
Sure.
All right. I started with damages because I think for this conversation, that's really what we're looking at in terms of, is this a good case to go to trial? Is this a good case to settle? Unless you have a very clear, favorable liability case, I think that conversation and that focus is first and foremost. With liability considerations, I always start with what is the theme, and remembering and reminding my client that argument's not evidence. We might think we have the best case in the world, but how am I going to get it in? How am I going to prove it at trial? And using that to drive the conversation on what the exposure is, what the reasonable settlement value is, what the potential verdicts are, not forgetting that good argument doesn't necessarily translate into good evidence. So what is the evidence? How am I going to prove it? What are the factors that I can't control? For example, you know, the woman that I spoke about earlier that has pre-existing cerebral palsy since birth. How does that, even if I have a strong liability argument, how is that going to weaken or dampen my liability evidence, my liability arguments? Is the jury going to care? And I think of that question all the time as I'm practicing. How is the jury going to care? What do I need to show for the jury to care about this evidence? I'll turn it over to you two if you'd like to weigh in on any of that.
Agreed on all points, and I think that means going hand in hand with that is that we as attorneys have to share bad news sometimes, right? And we need our clients to listen to it, right? Because you can feel really good about something, and Heather said it more articulately than I will, so I'm not going to stumble upon it. But you know, Melissa and I get along great, but when I'm calling her, it's usually with bad news, right? There's something, you know, it's I have to do that. My job is to say, not, you know, that's our job as counsel, is to say things that people don't want to hear, because by necessity, if I'm dealing with it, that means I'm dealing with it. But what I don't want to do, and we need to be careful, is we don't want to just drink the client's Kool-Aid, right? Because sometimes clients will say, hey, this one is a dead bang winner, 100%. You say, yes, it is. Well, no, it's not, right? Nothing is a dead bang winner in our line of work. And it's not doing a disservice to the client to say that, in my opinion. It is doing a tremendous service to the client to say that, to make sure you understand there is a way we will do everything right. I promise we're very good at what we do, but even if you do that, there's still an element of chance, and we have to do that. And if that angers clients, that's okay. But it's far, for me at least, it's far better to have the frank conversation.
Right.
You want to talk, Heather? Oh, unless Melissa has something we can.
No, go ahead.
I was just going to add that I think the analysis always to the client that I give is, we are going to argue this, the plaintiff is going to argue this, here's what I think is the winner, or here's where I think, you know, the scale sort of tips. In terms of third-party liability, tender considerations early and often. On the GL side, is this a case I can tender? Do it right away, because if I'm claiming, you know, or seeking reimbursement of defense costs, it's from the date of that tender typically. So I want to start that clock early. And then non-delegable duties. I represent a lot of property owners for GL cases, and we then often tender to a janitorial company or a security company, but explaining to the client at all times, rather often, that the property owner has a non-delegable duty. So even though there are subcontractors, that doesn't absolve us of all fault and responsibilities. So explaining that several times throughout the life of a case.
Let's talk. So we've got about 10 minutes left. I want to make sure we get through these damages. If we're going to be short on anything, we'll be short on the end, which is who our jury pools are. There's a lot of awesome resources in there that if you want to look at it, what jurisdictions are conservative versus more liberal versus more moderate, what judges are like. It's more, we can make that more for you as a take home. We can look at it now. We can stick around and answer questions too, but let's talk about these final issues. So do you want to talk, Heather, Melissa, about witnesses and how that plays in?
Sure, and I think we've been talking about this from the beginning. Who is the jury going to believe? What are the credibility considerations for all witnesses? If it's a case where it's plaintiff's experts versus defense experts, the client needs to know what that means, so that this is going to be a battle of the experts and the jury might just be sitting there yawning. Are they going to be sympathetic to the plaintiff throughout all of that? If you got a sympathetic plaintiff and then it's expert versus expert, the scale is probably going to tip on the side of the plaintiff. That doesn't mean it's not necessarily a trial candidate, but that does affect how we value the case and whether or not we do recommend that this case be taken to trial.
On the employment side, it's all about personalities. It's like almost exclusively who the supervisor is, who the decision maker is, and we could spend all hour talking about that, or just because how a witness, whether the plaintiff or a witness, makes you feel or makes the jury feel drives these things. And so there are cases that we settle because we are worried about the way it will look when someone may have made a perfectly justifiable decision, but they're a jerk about it, or they communicate it poorly, or they just, the way they carry themselves, the kind of thing where it's like, I don't really like that person. And that's hard to say. And sometimes it's, I'm saying that to the owner. I'm saying, hey, you know, this is your company and a jury's not going to like you. But I have to say that because that goes in the soup of all of this. And to say, look, you may have the best argument in the world, but if they don't like the way you make them feel, they may well go against you. That's unfortunate, but it's true.
Yeah, it's obviously hugely important to be open-minded about how your own witnesses are going to be perceived. And I mean, and I do, like I mentioned before, I do try to take opportunities to experience firsthand, you know, who's on the other side and how, and try to evaluate how they're going to be perceived. And, you know, another way that I do that is when we get the opportunity to mediate. I mean, obviously I'm not usually directly in the room or in the Zoom room with the plaintiffs, but I just ask a lot of questions of the mediator. You know, how do they come across? What is your feeling about the dynamic in the other room? Who's driving the train? What's the financial, is this a family or a resident that has a lot of means? Is it not? Just to try to get as much intel as you can about how they're going to be perceived by juries.
And then the last one I had on liability is MSJ potential, evaluating it early, preparing it promptly, even though we're seeing trial dates really far out. It's, if you can do an MSJ, if you have a basis to do an MSJ in your case, even if you think it won't win, it will make the plaintiff and the plaintiff's counsel have to work hard, and it may drive settlement early. So as soon as I receive a case, I am thinking about that, thinking about MSJ potential, and starting to prepare it so that we're not preparing it on the last day prior to, you know, the 81 days before the hearing and then 30 days before trial. One little thing to note, which a lot of you may know, but effective this year, the filing deadline for MSJs has moved up by 6 days. So just keeping that in mind, and if you can, never wait till the last minute because it can save your client a whole lot of money to drive settlement after an MSJ is filed.
I think, Heather, jump in. I'm about to say something that's more in your world, but I think this is an interesting concept that comes up less in mine. I think it can also be an effective tool to smoke out experts, right? If you have a case that's going to be an expert case, and you know that there's going to be somebody on the other side that's going to be espousing the position that plaintiff is about to take. If you file an early MSJ that needs to be opposed with some sort of expert testimony, what you're going to get in the opposition to the MSJ is a declaration from XYZ expert that if you didn't do that and you waited, expert designations, depending on the jurisdiction, are typically a couple months before trial. If you file an early MSJ and you find out who their expert's going to be on the floor on which someone slipped or on the tires on the car or on the whatever, now you know who that is. And there's some value in having that information earlier. And it's the easiest way to find it out, because if you ask them, they won't tell you unless they have to.
Absolutely, and it's a very good way to get a lazy or quiet plaintiff's counsel to pay attention. If you can file one, generally you should.
All right. I was the one who was supposed to keep us on track on timing, and I've done a poor job of that. So now, Heather, can you, in 4 minutes, tell us what you want to tell us about venue, and then tell people what the resources are? And
Sure.
my fault.
So the next slides basically just have a bunch of sources that you can use when you have a case in any of the, I mostly stuck to Southern California in the following slides, but they have links on your PDF copy of the PowerPoint that you can click on just to familiarize yourself with the venues of the cases that you have. This is the most recent US Law Network kind of state judicial profile by county. As you can see, San Diego is conservative, Orange County is moderate, Los Angeles County, no surprise, is liberal. I was surprised that San Bernardino and Riverside were moderate, but I think that makes sense. Those are more nuanced than probably San Diego County. We could go to the next slide, which will have all the different links I was talking about. I find these rather helpful. I've had varying over the years, different times where I've not really paid attention to these types of facts, but I think they're really important, especially now, because I think the demographics are changing in a lot of our counties in California. And I think that's what precipitated this webinar today, is what does the landscape look like after COVID? What does it look like in this political environment? How are we assessing what the jury pool is going to be? So I think now is the time to kind of pay attention to what data is out there and how is it going to affect our cases and what verdict we probably will see for a case like this, which I think is different than 3 years ago and then 5 years ago. You can move on. I know we only have a couple minutes. Also just evaluating who the judge is. And here's a few sources that you can use. And then Lexis Litigation Analytics is really useful for judges. You can go on and see how they ruled on past MSJs and motions and at trials. So that's really useful. Go ahead. And then opposing counsel, obviously looking up opposing counsel through Lexis again, which oh yeah, I have that on here. So through Lexis again, you can see the opposing counsel attorney and firm, what cases that they have taken to trial, their settlements, their past verdicts and whatnot. Next slide. There we go. What's the takeaway? I'll let Ryan give you the takeaway.
Oh, okay.
It's on you.
Look, our job is often the bearer of bad news, but we want to take all these factors in. No two cases are created equal, and I think that's important for all of this, right? We have to take every single thing into consideration in trying to make an assessment, and the best clients and the best general counsel with which we work are the ones that appreciate that, right? We will fight for you. Look, our firm, we try cases. We will take them to the end. We are happy to do that, but we need you all to pick the right cases. It's the most important thing. And that doesn't mean, look, you can tell us to go try a loser because there are different reasons for that. That happens. We've done that. It's okay. But we want it to be thoughtful. We want it to be considered, because if you do that, then you're doing it for the right reasons and you're handicapping it the right way. So hopefully this gives us some things to think about. Hopefully it helps you all listen to us better when we tell you bad news. Thank you all. I think we're right at 1 here. Happy to stick around. At least I am. If there are questions, and obviously feel free to email us if you have anything else. Thank you for the time. Thank you, Melissa, for joining us. And not saying any bad things about how
Pleasure.
we are as counsel. And Heather, obviously, thank you.
Thank you.
Right.
Take care, everybody.